Roger, if you could introduce...
Sorry, I'm not hearing.
Would you be able to commence the meeting with a karakia?
Oh, okay. You want us to start?
Yes, please.
Okay. Kia ora tātou. Tō tātou karakia tīmata. Ki noi tātou. E te mato kaharawa tēnei mātou au ponongo ina nei ki a koe. E te mātou e karanga te mātou ki a koe, ki te tata mai koe, ki tēnei rōpū, kine kōmitsi, hei awhenatia, hei arataki a mātou i ngā momotake, i mui a mātou i tēnei ahiahi. E te mātou i ngā wāka tō e mahi ai mātou, hau korore ai tau e ngā rotapu, kuhu prai te hoki tō mātou ariki. Āmene.
Āmene.
Kia ora, Roger. Well, tēnā koe te kai karakia, Roger, and ngā mihi nui ki a koutou katoa. Kua taimai nei ki tēnei hui, and tēnā koe Katarina on the screen. So, welcome to you all. Thank you for being here. It's actually been some time since we last assembled, back in June. And without further ado, I think I'd just like to ask if there's any notices at this stage. No, I see a couple of hands going up in the air, but they look like they're just adjusting sleeves. So, I've got an apology from Chair Barker, who has some urgent business to attend to. That could be recorded. Are there any other apologies? Well, could someone please move the apology be accepted?
I'll move.
All in favour? Anyone against? All right. I think Councillor Ormsby. All right, bearing in mind the subject matter or kaupapa of item 6, are there any conflict of interest declarations? Oh, all right. If we could now perhaps then move to the minutes of the previous meeting, which you would all have an opportunity to read, dealing with the amended terms of reference to ensure we have all relevant powers and delegations, and has led to one of the items on today's agenda around mana whenua involvement in decision making. Would someone please move that is anyone willing to move that they are a true and correct record of the meeting? Councillor Ormsby, thank you. Do we have a seconder? Yep. Dr. Marker. All right. All those in favour of approving the minutes, please say aye. Anyone against? Carried. Okay. So we can move, I think, to the meeting agenda proper. There are two applications immediately before us. Before we move to that, I just want to say there's a couple of other items that I want to add to the agenda, and they are just the work program in front of us, and to note that we need to make a further appointment from the Regional Planning Committee, and I have been in contact with Tanya Huata, who is no longer with the Regional Planning Committee on behalf of Ngāti Pāhewera, and so she's not with us here today, but we'd like to acknowledge her role on this committee and her input to it. And equally, she's shared with me a need to update the table attached to item 6 of the agenda. She is now an accredited chair, and with extant certification up till 2024. So that needs to be corrected, and we obviously need to bear in mind Tanya's potential involvement in future hearings. So just wanted to, I guess, close that out as a preliminary matter, but if we could come back to those two items perhaps after we've dealt with item 6. That's the appointment of a replacement RPC member of this committee and the work program in front of us. Okay, with that all said, can we move to item 4, please, which is the appointment of a hearing panel for the Tukituki Tranche 2 resource consent applications. We have the paper prepared by, well, Malcolm, perhaps you could speak to that.
I don't know if there was going to be a discussion about changing the order. because by pointing...
No, we didn't. We just talked.
Okay. So first item is the tranche 2. This is 15 million cubic metres of water available through the Tuki plan change that has been applied for by 8 parties. So it's from the Ruataniwha groundwater area. We've looked at a panel and are recommending Brent Cowie, Tony Petch and Ro Kurikuri as being the commissioners for that panel. He has looked at a couple others, Paul Cooney as a backup, and Antoine Coffin was another name, but Antoine is not available for this hearing. It's scheduled pretty well, trying to lock it into July, the first week of July. So availability, it allows the road to be available. Don't fix that date, then we will struggle a little bit to have him available.
So through you, Chair, just to add to that, in terms of trying to select a panel for this consent hearing, we had to be mindful that the organisation has already stated publicly that we would have an independent panel hearing this decision, given the complexity around it and public interest. So in terms of tangata whenua membership of the panel, we have gone through, and this is slightly relating to or going to the next, the third paper on your agenda today, and we've gone through the list of local tangata whenua making good decision qualified hearing commissioners that we have. We were initially considering approaching Councillor Ormsby, but of course not independent from HBRC. And then going through the list, we had approached Tanya Hopmans, who was not available. In terms of the rest of that list, and you'll find that in the back of the third item, they're left with 4 potential members that you might want to consider as a committee, and that would be Bonnie Hartani, Tania Huata, Toro Waka and Hayley Lawrence, who all are current making good decisions qualified hearing commissioners. They don't have any experience as yet. But of course that goes to our third item on the agenda. So I'm just raising that for you now to put that into your consciousness.
Thank you very much, Katrina. I was going to touch on the issue of the rationale for the recommendation of independence, and I understand that it's an issue which this council has a strategic priority regarding water security, and I can quite appreciate the need to keep some daylight between the council and its strategic position on that issue and these applications. Now, could you just remind me, who was the third? You had Bonnie, Tanya, and...
Tanya Huata, Toro Waka, and Hayley Lawrence.
Is Hayley in there? She in the
No,
table?
she wasn't on, I actually found her name later, so she wasn't on the list. She went in that paper.
She's Mangahururu Tangatu.
A note, although it's relevant to the paper, to follow, just for completeness, it looks like Te Tai Whenua or Hiratanga and Ngāti Kahanunu Iwi Incorporated are both submitters to the application, to the extent that that's relevant in light of the Simpson Grayson advice in the paper to follow. All right, so does anyone have any questions for either Malcolm or Katrina before we proceed to consider the recommendations as to appointment of commissioners?
Yes, please, Chair.
Fire away.
Kia ora. Thanks, staff, for bringing this paper to our attention and the consideration of possibly me being, starting off with somewhere. But I totally agree that, to keep me removed from this process, particularly in this consent. My question is around Brett Cowie, around what relevant experience or expertise he brings particularly to this consent, because I couldn't find clearly what his area of expertise is as a commissioner.
I don't have his qualifications off the top of my head, but he's got experience as a surface water ecologist. He has a doctorate in that space, I think.
Yeah.
I know he's sat on a lot of panels, so he's got chair competency as well, so he's able to bring both the sort of the technical and RMA type skills into that mix.
Great, fantastic. And the second question was going to be around if all three have the chairing qualifications as well, or it's just Brett.
I think it's just Brent. Sorry, that's a typo. It's Brent Cowie.
Yeah.
I don't think Tony Pitch has, but I sort of selected him because of his groundwater experience.
Yeah.
Yeah.
Mr Chairman,
Fire away.
so if I may
Please
comment,
proceed.
I know Brett Cowie well. His expertise is in water quality. He has a PhD in this area and over 30 years experience. I was of the understanding that he's on the verge of retirement, so I don't know his eligibility, but just to...
Thank you.
I did speak to him, and he sort of made that point that Tank was going to be his last hearing, but he came back and said he's willing to do this one.
Thank you.
So you're suggesting a July hearing, which would mean that Roe is available?
Correct.
Right. Are there any other, before we move to discussion, are there any other questions on the paper?
Yes, there is one, Mr Chairman, is that this is a little bit difficult to discuss before we haven't discussed the other item on the agenda, because there's a huge overlap between that and the actual decision for the people that will constitute this panel.
Are you thinking that perhaps we might move on to item 6 and deal with that and then come back to this? Because the issue that I was going to raise is whether, given that we've got Roe, Kitty and Antoine there as independents of this council with cultural expertise, perhaps there's a role for mana whenua in that. That's the point? That's the issue? Yes?
Yes, well, and considering tangata whenua representation, notice should be taken of the organisation they represent and whether that organisation has submitted in this. I know in a couple of cases that you've just read out, their organisation has submitted. So I suspect that's a conflict.
Well, in that case, we need to delve into the advice, as you say. So, because, is there any objection to us moving to item 6 to get our heads around that paper before we come back to this? Because one point that it raises is just because the entity submitted doesn't mean someone of Ngāti Kahungunu couldn't be a hearings panellist here. We're all quite clear on that. Okay, well, let's hold that. And I think probably your insight there, Dr. Marker, would apply equally to the Ravensdown one too. So let's just deal with item 6. So if we can just sort of park the current item. Now, so the author of the report would be, who should we hear from?
I'm happy to speak to this, Chair. So just for introduction and to remind us all how we got to this point where the paper is now before you. At the previous hearing committee meeting, the members noted that they wished to see a greater representation of local Māori appointed onto the resource consent hearing panels more often, that we had some qualified making good decision panellists that make up this council, relevant RPC members, Māori committee members, and even this committee, and that there was needing to be more opportunity for those members to be put onto hearings panels, not only to get experience but also to have more local input from a Māori cultural perspective. So we have been to Simpson Grierson. Simpson Grierson have provided us with some very thorough legal advice, which is attached to the rear of the report. In that advice, as the Chair's noted, being a member of a committee, of an iwi, hapu, PSGE, type whenua does not make a conflict of interest automatically. It's about position and about who's made a submission and who had authority in making that submission. In the officer's report, what we have tried to do is set out a process that you as a committee would undertake in terms of receiving recommendations from officers and making an assessment of the likely conflict of interest of those recommendations, as would the staff before they put those recommendations to you. In terms of the questions that you should be asking of us and yourselves in terms of making those appointments, that is set out in the report and intended to be a guide that you would then refer to on an ongoing basis when we come to you with recommendations.
Thank you, Katrina. Before we move to questions, just to note my recollection per item 6 of the Regional Planning Committee meeting was that an opportunity was sought to have further input to that report. I'm not sure whether that's been received. It seems from on the face of the report it hadn't prior to being authored. So I guess my question is, have you heard anything further from the RPC about additional, or from the Māori Committee, about additional content or perspectives?
So Chair, I spoke with Api about his comments from that committee. He was going to advise, he didn't have anything specific. He said that the Regional Planning Committee had provided comments to their advisor.
Sorry,
Their advisor.
to their advisor.
Yeah. Ricky Ellison.
Okay.
Thank you, behind me. Sorry, name was a long day. Provided advice to Ricky Ellison, and they were going to seek those comments and forward them on. To date, I haven't received them, and I was expecting them before now, but we have not received them.
All right, well, look, we can have some questions, and then we'll move to comments and discussion. Just to signal, though, that I think this meeting would usefully provide an opportunity for any additional perspectives in terms of tikanga as to the factors that have really been put in there from a kind of Western law perspective to guide our discussion. So before we, as I say, move to that, I just wanted to foreshadow it. Any questions on the paper that anyone wishes to ask?
Is Roger Marker and my name supposed to be on the list of making good decisions?
I'm wondering if Roger isn't current, that's why I didn't put names on.
And mine's expired as well, as same date as Brian Gregory.
Oh, yeah.
Yeah.
Okay, so I put 2 on there which have expired end of 2021. So I didn't,
Yeah, December, yeah.
Okay, discussion. Particularly interested in perspectives from our Māori Committee and RPC Committee advisors, and any obviously the other members as well.
Yes, I have a couple of comments that is raised from this. So, first of all, I totally support the idea of having a cohort of experienced tangata whenua, both experienced and qualified tangata whenua. I think that's a given. The question is, how do you get this? And as Mike and I were just talking before we came in, having good decisions certificate is like getting a driver's license. It doesn't make you a driver. And that's the kind of way it's looked at from officialdom. But in reality, it is, if you've done a good decision 2 years ago and never sat on a panel, then you're just an informed sort of outsider to it. So there should be some system by which to blood these people and to give them a bit of experience. There could be a variety of ways of doing this. So some of the more perceived, less complex claims, a person could go straight on a panel. If it's perceived complex, or to be complex, then probably it's not a good idea to put, unless they're accompanied by a fairly experienced panel. But there are ways, and this could be discussed, that the nuts and bolts of that could be discussed, because it will be resource. It will have resource issues. If there's workshops, if there's other things, then that will cost the council, and they should consider investing in this, other than having individuals simply go and do a good decisions course. So that's the first point I'd make. The second one, I think there needs to be quite a degree of subtlety in this. So you've just made the statement that belonging to a niwi, a hapu, a tai whenua, something else, treaty settlement board doesn't conflict you. Well, that's not actually correct. A niwi and a hapu are cultural institutions. So the rules around membership, the rules around how they operate is solely on cultural grounds, and therefore I don't see how they can be conflicted. However, if you're a member of an institution, particularly one that's in the habit of putting in submissions, then you actually have a vested interest in that. So there needs to be a little bit more clarity, and you can't generalise on Māori organisation just by saying things like that, because they may well be conflicted. So if you're a board member of a tai whenua, a board member of a treaty trust, and your trust has put a submission in, then clearly you're conflicted. But if you're simply there by whakapapa, then there's no conflict. There can't be, because the two things are opposed. I don't like this idea of jumbling those things up together. I think they have to be unpacked to be a realistic when you come to apply this. So, and getting back to the complexity, that's what I'm wondering about the tranche 2 one. How legally complex is that? I would have thought it's reasonably straightforward. Therefore, the experience of a panel member, a tangata whenua panel member, in terms of the technicalities of the law and the practice, are possibly not as important as, say, if they went on a water conservation order or a larger type hearing. That's just an observation at this stage that I was going to ask, because to me the tranche 2 is fairly black and white, isn't it? I know you're the lawyer.
Dr. Mark, if I could just respond to those two aspects of what you just shared in your kōrero there. The first point is that the paper is actually, I think, in the same place as you, is saying just because you're whakapapa to a hapu or an iwi doesn't raise a conflict. But it says, and it gives you some guidance, I don't think it jumbles the two up, as opposed to actually enables you to operate within the construct where, for example, if the member of the hapu or the iwi has an official role on the submitter entity. If the submitter entity, I think you've just introduced a particular, another factor that's not in there, it has a modus operandi or habitually is active in that context, that would compound if they had an official role. And, did they actually help prepare the submission? That takes you from the place of, I think you'd agree, just being connected by whakapapa into a more active conflict place. You'd agree with that? Okay. So that guidance is in there. Yeah. On tranche 2, I'd have to say it will be horrendously, factually and legally complex.
Okay. That answers that question. I was just, the other thing I'd like to say is that while I've got the table, is that the tangata whenua in terms of local tangata whenua, it doesn't seem to me to be that urgent in this sense.
Right.
So if a Māori, qualified Māori person from outside the district sat on this, from my tangata whenua point of view, I couldn't care less.
Right. So, yeah.
There are other issues which I could care that really need local knowledge, but I'm not sure that the tranche 2 is one of those issues.
Thank you. So personally, your perspective would be, when we come back to tranche 2, that doesn't sort of cry out for a specific rohi-based perspective.
Yeah.
Okay, Katarina, I'm going to go to you on the wall now, because I may have missed you with some questions and things in the past. I apologise, I didn't go to the screen. Is there anything you'd like to share from a tikanga perspective, or about the Simpson-Grierson advice and recommended framework for this conflict issue?
Tēnā koutou, kia ora Martin. Look, I've been sitting here just even trying to articulate, but when I saw the paper, actually never felt quite stripped down as a Māori around conflicts. But I do agree when it comes to looking at the generality of the issue around the tranche, tuki. I tautoko matua Roger, I tautoko Roger's kōrero around it doesn't matter who you have there for Māori, so long as the worldview is still paramount, and when it does come to urgent, I'm not going to say high priority issues for Māori and for mana whenua, well then you would need some mana whenua people there to represent. Yeah, it's quite hard to be Māori in this position. And from Ngāti Kahungunu, oh my gosh. But when it comes to the RMA, you've got to see that the principles have to be honoured. Minimum principles must be honoured, and the partnership. So look forward to an independent tāiao unit for Te Matua Māui, full of people that can represent. Yeah, that's my whakaaro. Mauri ora. Not really a question.
Well,
I've never seen such a paper really stripping it down. It's a sad day.
Kia ora, Katarina, I'm sad to hear that that's been the impact of the paper on you. Its purpose is actually, I understand, to be helpful, to enable us to better equip mana whenua through greater access to involvement on hearings panel. It's not going the other way. It's actually trying to give us a framework that is safe to make decisions where we can be inclusive. That's its kaupapa, right? So
I hope so,
yeah.
Martin.
But did you just share the point, as I just want to check that I've heard it right, that if the application concerned has a particular issue or impact on the mana whenua of a particular rohi, that is where they should be involved in the panel? Is that what you were...
Absolutely, I support that kaupapa.
Yeah, well...
Yeah, absolutely.
Unfortunately,
But for more general issues, sorry, I might not be articulating it properly, I've got a sore tooth. But I don't mind having just, someone out of the door here if it is more general issue for Māori. Because I would trust that they would have done their homework and connected with mana whenua regardless.
All right, thank you. Now, Mike.
Yeah, well, I'm part of the Regional Planning Committee,
Yeah.
and the members were quite adamant that we actually do have Māori on these hearings. I just look at the list, and without running Roger and I down, there's two ladies there, Bonnie and Henawai, who we've got daughters older than them, this is the group that's coming up and it's our future leaders. We want to see them on these panels without degrading the rest of them. So, and that was the feeling of the Regional Planning Committee. How do we get these people on there when you've only got 3 members? It was debated, you could have one as a observer, but then we'd say, well, does that apply to Pākehās? Do they have an observer? It's just that you're going to have to, if necessary, stretch to 4 commissioners, but they were quite adamant. We actually need them there for, especially knowing the local issues. I did my apprenticeship with Christine Scott, as did Ewan McGregor. He got told off more than me during the hearings, and if you came through 2 or 3 hearings with Christine Scott, you actually knew your business and were told that you need to be up to a high level. So Christine's unfortunately gone, but I mean to say, we need young Māori coming through. So that was the feeling.
Thank you. Councillors.
Thanks, Chair. I listened very carefully to everyone's contribution, and I respect and all the points. I was very much interested in your description of the complexity of Tranche 2 in particular, and I can't remember your terms, but it blew me away. And the challenge is bridging, getting a safe, correct decision which can't be challenged, and trying to nurture exactly as Mike was just saying and Roger's alluded to as well. It's that balance, and every time I come to this committee we kind of have the same discussion, and so there's got to be a model to help facilitate that and achieve both. I don't know what that model is, but it always comes up. So I think TAC Council, and guided by what you've said, in that the complexity, particularly Tranche 2 discussions, and we often try and compromise, go, well, let's have 4 then, or 3 or 5, and then we get into the discussion of, well, we need an odd number in case there's dissent. So I continue to keep an open mind, Chair. I guess I did have a question just about those that have opposed and the link with the tank hearing. So Brett and Tony, is it? They may well be on there. Is that very? I don't want to compromise the discussion, but it seems, is that very helpful on all things water, Hawke's Bay, and their knowledge of tank, or is it just a good tick for their experience? How crucial is that?
It's really a tick for their experience. Yeah.
Just experience.
Yeah.
Because they need to look at this in isolation of whatever's proposed.
Well, it's a different aquifer, but I would have to say if they can get their head around tank, and despite the horrendous complexity of it, which I think was the term I used, they should be really able to cope with Tranche 2.
Yeah. And then one thing Katrina said earlier, I think you said this organisation has publicly stated, did you say the chair would be independent or the entire panel would be independent?
I'm fairly certain it was that the decision would be heard independently by a panel.
So what standing does that statement have other than that's what we'd like to do, perhaps?
Ultimately, this committee can make a different decision on that, but it was viewed that the application was so close to this organisation,
yes,
it was best to ensure a legally robust decision,
yes,
that we had an independent panel.
I understand, and thank you, and everything I hear keeps reinforcing that. That's the end of my questions, Chair.
Thank you. Well, there was an opportunity for comments as well, so any other comments? Okay. Yep.
My only comment is here, we'll obviously do our best as a committee to find the right solution. But like anything, there'll be some people that may miss out. Hardest thing is someone's going to come number 4 or 5 or 6. We'd love them to be around the table, so the balance is this test. And I guess the lens at the end of the day, or my lens as a councillor, has to be the safeness, longevity, robustness of that decision, whilst wanting to serve all these other aspirations I have for our people in our region.
Right. Councillor Ormsby, you've been very patient.
Okay, kia ora. Hey, I just appreciate, Katarina, your comments around how you felt about the paper. And I can see how you can view it that way. From my point of view, I think it helped clarify for myself. So thinking about wanting to get onto a panel and having that experience as a panellist, not so much as a secondary behind. And it helped me clarify for myself some of those grey areas I did feel before this paper came. So I am to a degree thankful for the advice. But next steps moving on is how we provide the guidance and framework in the context of the hearings committee and how we use that, knowing that it's on a case-by-case basis, and also how it feels comfortable for our tangata whenua panellists or possible panellists as we go along, and just testing that also. So, Bonnie might not be available, and for some hearings she might feel that it is too complex, so she could say so and like to be a secondary. And in some cases, if it's not so complex, harsh, and it could be seen as brutal, but I think it does help clarify if you are in that grey area. Kia ora, thank you.
Anyway, are there any tikanga perspectives around this issue of conflicts and what Katarina's touched on that you think are missing? Because that's what I'm really wanting to know, because we've been sick. We've had this paper for 8 months since we first raised the issue, and I would like to get some sort of a landing as a committee on what we're going to do, so that we can then go back in a structured way and look at Tranche 2 and Rodenstown. So are there any major tikanga, Katarina's named one, that you think are missing?
No, I think, again, you take it on the consent, and whether or not we test around how it has to be a tangata whenua or just mātauranga Māori experience from out of the rohe. So it would be good to have a bit of a test within the model that's developed around looking at the need for tangata whenua versus outside mātauranga Māori knowledge.
So would a way to put that be, does it require specific cultural understandings unique to the rohe? Is that the factor you're touching on?
Yep, aye.
Because if you are,
General mātauranga Māori knowledge needed for that particular consent.
Because the thing about that factor is that it walks you straight into a potential sharper conflict. But you could at least balance that factor against, you could be of the rohe, but have had nothing to do with the submission, and never have said anything about it.
Can we liken it to like air quality expertise, water quality expertise on the panel, and then we have mātauranga Māori, but within that it's not that rigid. It depends on the consent that's in front of you.
Yes, well, I think that would be the case for all applications. So it would be on a case by case basis. So what the guidance is. Okay. So thank you for everyone. So it seems to me that if there's anything missing in here, does it require a mātauranga understanding specific to the rohe? And so you look at each application, and you could add that to the factors that are in the paper. For example, we might come to Ravensdown and go, there's something peculiar to Awatoto or that wider locale that we need to bring into the mix alongside the other factors in the Simpson-Greason device. And I do think that that factor is possibly, if anything, missing. But it doesn't need to be the trump card in any case. It's a matter of us looking at each application on the merits. Who were the submitters? Who was involved in those submissions? What are the specific interests that are at stake? Looking at the long list, and then within that long list, applying those factors and with the aspiration of building the capability and experience of mana whenua making decisions, because actually that is a factor that's not kind of in there. Can I just take you all? So I actually found the Simpson-Greason advice and the guidance really helpful. Let's just look at paragraph 19 of the paper. Prepare a long list of people with the MG team. We did that before, for example. Some of the names were named. Bonnie and Tanya and Doyle and Hayley. Mm-hmm. And then you could go through each of those and they are, I guess, specific to the person. Then you could add like a 19.3, which says specific to the application. Are there aspects of the application which require ngā tauranga understanding specific to the rohi? And then does this application provide a suitable opportunity for including new mana whenua appointments to the panel, right? Did someone write that down? It's written to tape anyway, because I think if you had those 2 points underneath 19.2, you would then be looking at the specifics of the application and the specifics of the people involved and balancing the different factors in making a decision. All right? Okay. Does anyone disagree with what I've said? Right. Well, if you look at the recommendations in the paper, the Hearings Committee recommends that the Regional Council agrees, not significant, the usual boilerplate, supports the involvement of more local tangata whenua, yep, supports the proposed guidance to avoid conflicts of interest with the following amendments. And then they would be, as I just read out. Does the application require that local tauranga, and does this provide an appropriate opportunity for new members, new panellists, what I said before.
To clarifying decision paths.
Yes.
And which may be slightly different, say, for the two we've got here today, because of, okay, well, we're at 19.2 now because of exactly what you said, say, Awatoto, for example. Therefore, this cohort is actually now this potential cohort.
Yeah.
So that seems a pretty reasonable and rational approach to the item, which to the issue. I think I'd be very much in agreement with that, as long as we remembered what you said.
Well, I think it's written down. The point is, it just means you make sure you go through the discipline of the exercise in each case, and then it's up to our judgment. Any thoughts? Or?
So through you, Chair, I think what I agree that can easily be done, and what has happened in the past is staff have undertaken that process, just not documented it. So every time the officers make an appointment, they go through this process on paper in their heads, but don't write it down. Yeah. And so what we would be doing going forth from here is documenting that in every decision or recommendation that we bring to you.
Yeah.
And this will become part of the process and our recommendations to you that you will then go through in part of your decision process.
Yeah. Okay. Well, I'm going to move that we adopt the recommendations with those two additional clauses. Would anyone like to second that? Councillor Ormsby. Okay. All in favour?
Aye.
Anyone against? All right, so with that, we can go back to tranche 2.
Excuse me, Chairman, can I make a comment here as an observation as much as anything? And it's
Does it affect the resolution?
what Councillor Ormsby just raised there, that maybe the regional council...
Before you do, Dr. Marker, have we passed that resolution or not? Do you want to speak to the resolution before we pass it?
I thought we'd passed.
Yeah, I thought we passed. Okay, so carry on. Yeah.
That's fine, yeah. But before we go on to more specific things there, so my train of thinking was this difference between tangata whenua local and mātauranga Māori expertise. And that raises another, I don't want to complicate the picture, but so they're actually could be two different things. So that a tangata whenua who's good decisions qualified and experienced in panel, well, everybody assumes is that they know a lot about the history and about the whakapapa and everything else that goes with whatever's under question. That's largely intuitive knowledge. There are other people who are expert in mātauranga Māori from all sorts of other lines. And you may or may not get that in the one person who sits on a panel. In another setting that I'm familiar with, that I've worked in, there was often a mātauranga Māori there who had full speaking rights but no executive decision-making rights. So that those of us who were younger and active, we could roll our sleeves up and get into the issues, both legal and cultural and all the rest of it. And this other person that was on the panel would tell us if we were going astray from Te Kanga Māori or bring us back to, but they stood slightly aloof from, so they're not an appointed member as such, but they were formally attached and accepted by the general public that they were allowed to be attached to the panel. I don't know if the law lets you do that, but I think, which leads me to the next suggestion, that if you can bring in an external expert to do with water quality, you can also bring in an expert to do with te ao Māori, if required, as opposed to a Māori member sitting on the panel. So I want to leave that on the table for future discussion and to bring that in as regional council gets more sophisticated in the way they deal with these issues.
Thank you, Dr. Marker. It's a very poignant or pertinent, I say, both perhaps, comment. I'd make this response that any hearing panel can appoint experts to receive advice on issues raised by the application if they feel the need for it. Councillor Ina raised the issue of the tile unit. Could be another resource. We have at every hearing that I've been in the benefit of the reporting officers and the engineers and the noise experts, and so we can certainly have those resources at our fingertips from that more broad. And you're quite right, you don't need to have the world's leading expert in mātauranga generally on every hearings panel. With that objectivity, there are other ways to do it. Can I just give you the converse point? Bear this in mind too as we look at the fact that does the application require specific expertise to the rohe. It is the submitter's job, in a sense, to tell panellists what it is particular about the mātauranga of that rohe that is troubling them, or not, actually the reason for the application. So it does cut both ways. You don't have a complete vacuum of understanding of local specific mātauranga just because you've got the likes of Rai Kirikiri on the panel. But it does throw back, a burden on the submitter. Okay, so I think there was a good discussion. Can we come back to tranche 2, please? I got the sense from at least you, Roger, that you didn't see this as a burning case for Rohi's specific input in terms of the fact that we've just touched on. Does anyone have a burning ambition for this one as opposed to, say, Ravensdown, which I personally see a greater opportunity to have someone within our list potentially monitoring on that panel? Or are we happy with the recommended appointment? What do people think?
Chair, can I just ask a question of order?
You're going to flip the order again?
No. I'm just looking at para 2.
Yeah.
And one of the organisations there, with another hat I have on, engaged with that organisation, and it's potentially ongoing. So that their success or not in their application will strongly affect the value of that asset.
You're declaring conflict.
I think, I should just withdraw.
Okay.
Just to be absolutely safe, because it's big and a big deal, and I've only just noticed who that is. It's a long link.
Okay. It's a long bow link. Okay, fair
I
enough.
feel safer just not participating in that.
Well, if that could be noted, that Councillor Foss is not participating in this appointment decision for the reason he's just shared. I've also had the benefit of the submitter list, which you haven't. Does anyone want to see that submitter list before we turn to this? All right. Okay. Well, does anyone? Okay. It sounds like no one objects, so I'm going to move that we move items 1 to 4 of the recommendations. Would anyone like to second that? Are you seconding that, Dr. Marker? All in favour?
Aye.
Anyone against? No, that's carried unanimous. Okay, so that's tranche 2 sorted. Ravensdown. I'm going to... Do we need to... Yeah, we'll hear from the officers on this one first.
Through you, Chair, we've done a similar exercise with Ravensdown. And again, this was one that we were particularly keen to get some local input into the panel. Unfortunately, Councillor Ormsby's conflicted on this one due to a submission
I'm going to ask for the submission list.
by Pahuwera.
Oh, Pahuwera.
Is it?
No.
Oh, sorry.
Ngāti Pāro, yeah.
My apologies. Ngāti Paru. They have made a submission. So, but it does leave the panellists that we've discussed before. So I'll hand over to Malcolm and let him cover that.
We've got a suggested panel of 4 here, so Councillor Williams, Ro Kirikiri, which I think we should discuss a wee bit more, Louise Wickham, who is an air expert, and Dr. Malcolm Green, who's estuarine, water river process type expert. The submissions probably point more to issues around the discharge of stormwater to land and water, rather than bigger concerns about the discharge to air. But the air is a significant part of the application. The discharge to air is a significant part. So we felt we sort of needed two areas of expertise on the panel in terms of the science. Turning to Ro Kirikiri, that was probably without looking too far, and I think we should go through, we should work our way through that list and see if there is an alternate. And I don't know if Katrina wanted to raise it, but we had a little conversation between ourselves earlier, just thinking there could be 2 tangata whenua reps on that panel.
Make it 5.
To make it 5.
It's pretty heavy, this is the Supreme Court. Can I just test, Councillor Ormsby, were you involved in making the submission personally?
No, that's what I wanted to test. So I am of Ngāti Pāro Hapu, Ngāti Pāro Hapu member. I'm not involved with the Ngāti Pāro Hapu Trust, which I'm guessing is the submitter. I am the Waiuhaki Marae chair, but that's got nothing to do with the trust. They're different entities. The only possible conflict I could see, but I don't feel I'm put in a difficult situation, as possibly my brother is a trustee and a part of the submission, but I have nothing to do with the submission itself.
So that sounds exactly as the example Dr. Mark was saying before, and how you described it, and kind of covered under the Simpson Grierson. Whoops.
I had no idea the submission
It's
was
a great
going in.
example, but it almost slots in nicely
Yeah.
to, well, therefore, there's not a conflict, a
Yeah.
direct conflict, and a declaration of the individual's concerned. Well, what more do you want? And that does look like a great example of potentially a way through.
Yeah, well, I thank you for that clarification. Do you perceive any risk or do you have any concern that the applicant or one of the submitters might say at the hearing, we're worried about a conflict?
But I'd be happy to explain
You'd
that I
explain.
don't
Yep.
perceive it as a conflict.
Right, great. Okay, well, look, I'm with this. I think this is a sitter for getting some experience from a member of this committee, or, you know, from someone who's not on the committee that's in our long list. I question whether, Malcolm,
Yeah.
do we need Malcolm Green as well as Louise? Can I just test that? Do we need 4? Because, look, the Wairoa application, he was just absolutely fantastic. I don't think there's anyone would disagree the way he drew together the technical side, but equally understood the Mātauranga side as well. But is this hard stormwater as it is hard air? I say hard.
I think the stormwater is the more controversial
Is it?
issue.
All right,
Yeah.
okay, well, he'd be of great value. Well, look, are there any other questions on the paper?
I just have another testing question.
Yes.
Is with Rau Kirikiri's experience within Mātauranga Māori, is that
Yes.
the real expertise
Yes.
as to why he's on the panel?
Yes.
I'll just bring up that if I will be involved as a panellist, that I would like to come on as a fifth and not replace him, given that this will be my first hearing. So I suppose it tests that wanting Mātauranga Māori and then local knowledge there as well from tangata whenua. So this is another thing we can test out right now.
Well, I've got to say, I'm kind of in Roger and Mike's camp as I hear it. You know, we've got to give people a chance.
Yeah.
And you would be well supported technically, and if I'm on there, I think I'd understand the RMA stuff. I have absolutely no hesitation in involving you in that panel with your insights for Mātauranga and in the Rohi. So I don't think we want to go down the training wheels route. We've put that to bed in previous discussions. I got my head beaten, I think, for suggesting it at one point. So,
Your suggestion, Chair, because it's not a replacement of Mr. Green, it's
a replacement of Roe.
Pardon?
It's a replacement. We're dealing with a replacement of Roe, I think.
Yeah, exactly. So there's no need for both Louise and Malcolm. I think you just, did we agree to actually put that to bed, and then actually, then there is still, because we've been recommended 4.
Yeah.
So if there's no need for a Louise and Malcolm, given their areas of expertise and it's mostly air, then...
No, Malcolm said we need stormwater as much, if not more than the air.
Oh, sorry, well, I missed. I thought you were talking about another consent.
No, I wandered off into the Wairoa. But at the moment, the proposition, we're looking at 4 rather than 5. And I think rather than having Roe and, say, Councillor Ormsby's been put on the table at the moment, 4 would be more than adequate. And this would be an ideal opportunity. That's the way, applying the factor, is this an opportunity, an appropriate application for someone to gain some experience? Given the makeup of the rest of the panel, I would have thought so. Does anyone disagree?
I was just going to perhaps make a comment, Mr. Chair, your comment about getting beaten up last time. I thought it was actually Roger Marker who sort of made the point that perhaps didn't need that support. But I'm hearing him a bit differently today. And I actually conveyed that to Tanya Hopman when I was sort of seeing if she was interested in being on a panel. And she said she would like some support. She hasn't done it. She hasn't been on a panel as such before. And I said, but I can tell you that Roger previously said, you know, I think what you conveyed, Roger, was that you got put on a panel and it was sink or swim without without much support. And probably the benefit you had was Christine Scott sitting as chair.
But I think, Malcolm, there's 2 points here. There's being supported by a panel generally who understands the RMA and the process, and there's being supported culturally. And I don't think there is a need for this application, where I'm sensing, to have both Roe and, say, Councillor Ormsby, given that the support that I heard Roger talking about before is otherwise within the panel. Right? So that's kind of the training wheels point. There may be an application that's so culturally complex that you would do both for that, but this isn't it, I don't think. That's my sense. So,
So Chair, can I propose an amendment to the recommendation once we
you'd like
get
to.
there? Because I'm not, because I don't know how it's proposed. So I just, if we are looking at those recommendations, 3A, I'd like to change to recommending Councillor Martin Williams, Louise Wickham, Malcolm Green, and Councillor Ormsby as the
Moving that?
commissioners. I would, was the movement as an amendment
Yes.
to 3 before you go to there.
Right?
And I acknowledge what Councillor Ormsby said, and I appreciate that as the person that you are, but that the other names, the 4 names I'll put up.
Well, I think you're free, without, because the motion hasn't been put yet, you're free to just move that we adopt the recommendations with that change, and then someone could second it.
So I do so then?
Yeah, okay,
Thank
so
you, Chair.
Councillor Foss has moved 1 to 4, but replacing Rowe with Councillor Ormsby. Would someone like to second that?
Yes.
All right. Okay. Now it's the time for discussion. I just wanted to test this. I think, in fairness, we have got other candidates that we could put in place of Rowe that aren't Councillor Ormsby, who aren't here. I just wanted to say myself that I'm keen to get councillors involved in applications where it is appropriate. We are a consent authority and we are elected, and it'll be even better come November because we'll have 2 Māori councillors at the table who could potentially be on this committee. So I think my personal preference would be to draw from the council a pool of talent where available before we go outside of that pool of talent. But there are equally some very talented candidates otherwise. Has anyone else got any thoughts on that point? Is there anyone in that pool of talent that we mentioned?
Just a general thought,
Yeah.
because I did think about it as we were discussing it. Around the country, there are a very small sprinkling of Māori experts in this area. If someone from our number wishes to pursue that, then, in other words, they're not interested in sitting on the Māori committee or the regional planning committee or any other sort of notified board, but they are interested in the environment and are interested in becoming a panellist. Because in fact, I did that myself, so I wasn't of any committee and I paid for my good decisions out of my own pocket and put myself up to be someone who could go on panels. So I never had the support of any committee. There's that kind of person. When I look at the number of the people we've just been talking about, a couple of them have done exactly the same thing. So in other words, it becomes almost like a living. It's possibly their prime income source is sitting on panels. And from a tangata whenua point of view, that's good for us to have expertise out across the whole country on any, so they could put their name up for any kind of panel. So we might have a couple of people that have got the good decisions certificate, but because they're not on the in crowd, that they actually get overlooked. So I just want to put that out there, that if any young Māori wants to go into this professionally, then I personally support them all the way.
Yeah.
And I think the council should keep their eye open for that.
Right.
That we may have people that come out of universities or wherever with resource management degrees, etc., who do want to become panellists. So what I'm saying is that don't narrow it down just to those people who are in the Māori committee or the
I understand.
planning committee or closely associated.
That's
Yeah.
precisely why I'm testing this proposition, Dr. Marker. But I would like to ask, is there anyone on that list that has had a greater experience on hearing panels than Councillor Ormsby?
Probably not.
Okay. Is there any, Katarina, any further whakaaro from you on this motion? All right, I'm going to put the motion.
No, Eka, all good.
Okay, the motion's been put and seconded.
You're not conflicted?
What's that?
You're not conflicted as body of yourself?
No, I think we've dealt with that in previous papers. That's not a conflict to move that we appoint. We've decided that in the previous one. So, okay, all in favour?
Aye.
Anyone against?
Aye.
Okay, none against, that's carried. Right, just a couple of other matters I just wanted to raise before we close. We do need to invite another appointment from the RPC. So perhaps someone on the hearings team or the governance team could approach Api about that. To put forward a name, and that could be adopted at the next RPC meeting or however that works. I just wanted to note that there is quite a tranche, to use that word again, of applications in front of us, and I'd asked Malcolm through Katrina, I think, to put together a list. And we've got Silver Fern Farms wastewater discharge with a pre-hearing meeting that's been notified, and we've already got the ones that we've been dealing with. There are some Central Hawke's Bay District Councils, Takapu wastewater, largely resolved in a pre-hearing meeting that I chaired back in December, trying to save this committee a job, but I think that was a good outcome.
Thank you.
We've got possibly 400 applications coming for Heretaunga Plains renewals that are really best determined once we've got tank decisions, and I think there's a real likelihood that they'll be notified. Those applications could sensibly be heard in one again tranche. It's the third time I've managed to use the word, at least consecutively, but would possibly take a month to hear. It depends. I really don't know. I'm speculating, but I'm just telling you there is a huge work burden coming up for that, and I think that's one where we would need to draw in some expertise from outside this committee, as well as looking at appointments to it from within.
Do we need to end the meeting first?
No? Why would I? I haven't got much more to say. So just be aware that there is this line of work coming, and I just ask the officers keep us briefed ahead of time if necessary through me, so that we can convene meetings in good order and in good time and make sure we're resourced. And we're thinking about our calendars and capacity and opportunities and all those things. So that's all I wanted to say.
Chair, if possible, can officials able to put some holding invites into calendars, or some blocks aside, or you still don't know any dates whatsoever?
Well, just keep alive too, please, Katrina and Malcolm, when you think we're in a place to make a decision about these things, and schedule a meeting well in advance so that we can be as prepared as we can.
I suppose the point to make here is that I've shown in that third column notified question mark, so where it says yes, we have notified them. Anything that's saying in is basically that we haven't made that call, we haven't made a decision on whether it will be notified, and it's only really when it gets notified and sees submissions that we'll be seeking to set up a panel.
All right, okay, with that I think we can close with kia tau. So if you'll all share with me, inui tātou, kia tātou katoa. Te ātawhai, kia tātou ariki a ihukurai.
Mihukarati.
Me te araha o te
Te
ātoa.
araha o te ātoa.
Te whina tahitanga ki te wairua tātou. Aki.
Āmeni.
Thank you, meeting closed. Thanks everyone.